Hi, everyone. Welcome to this week's weekly live chat here at Immigration for Couples. I'm attorney Megan Pastrana. I'm happy to be with all of you here. I am streaming this live on Facebook, LinkedIn, YouTube, and Instagram. And I do see that we have a lot of questions coming in here. So before we dive into all of your questions today, if you are new here, welcome. We're really happy to have you. We host these weekly live chats at Tuesdays at 11 a.m. Eastern Time to answer your most burning immigration questions. Our firm, Immigration for Couples, we are dedicated exclusively to helping couples across the nation and across the world in navigating the U.S. immigration process. In addition to hosting these lives, we have a ton of free resources on our website, immigrationforcouples.com. Our amazing team member, Ria, is here with us today, and she's going to throw in the comments a link to our free resource center. You can download a free chapter of my book, Navigating Love and Immigration. The chapter is on relationship evidence and how to prove your love is real. We also have tons of free downloadable charts. And if you haven't already done so, wherever you're watching this, be sure to follow and subscribe. And that will ensure that you'll be notified when we have our next live event. All right. So I always like to start out by asking, where are you at in the world? And where are you at in your immigration journey? And most important, how are you all doing? I know it can be very stressful, especially right now, to be going through an immigration process. So I always like to start with those questions so I can gauge where everyone's at in their immigration journey. All right, so great to have you with us. So you're working on a fiance visa, and I know you have some questions, and we'll definitely go over those as well. All right. Let's see where, and Paul Winder, you're also working on a fiance visa. It's great to have you. Buenos dias, Rocio. It's great to have you with us as well. So you're watching here on Facebook. All right. So keep it coming. Where are you at in the world? Where are you at in your immigration journey? And I'm going to go ahead and dive into all of our burning questions here today. Looks like, and I think your name is maybe Antoinette. I'm not sure. So you had a couple parts to your question. So this is on a fiance visa. You're wanting to know about disclosure of protective orders, non-domestic in nature, and if that can trigger an additional review or delay. And does a post-filing low-level misdemeanor create any obligation to update USCIS? So let me talk generally about the fiance visa and protective orders and all of the questions that are on the petition for the I-129F petition for the fiance visa. So the starting point, I know you were asking, are you under an obligation to notify immigration? Yes, on every immigration application, it is your obligation. You must be honest in all of your questions and all of your disclosures 100%. Immigration runs background checks, not just on the immigrant, but also on the petitioner, the U.S. petitioner. And if there is something in the petitioner's background, such as a protective order, a no contact order, any kind of criminal history, that's going to show up. And so it's imperative that you are honest and the immigration isn't finding this and then coming back to you with a request for evidence or a notice of intent to deny for failing to disclose it. In terms of the impact on the case, it really depends. I know you said it's non-domestic in nature, but whenever I have a client that has a U.S. citizen petitioner going through the fiance visa process that has criminal history, we obtain those records. You have to obtain the records from that incident that have the charges, the disposition, what happened, and all of the details. All of that has to be disclosed in the fiance visa petition. The reason that the petitioner's criminal history is taken into consideration, the primary reason is first and foremost for the protection of the immigrant visa applicant. That when the fiance visa was created, that was a component that they wanted to include in there for protection of the immigrant. So that's why it has to be disclosed first and foremost. In terms of the impact on the case, it really depends on the specifics. There are some types of crimes that don't only need to be disclosed, but they can have an impact on whether or not the case can be approved. So if there's certain types of serious criminal history where there's abuse of another individual, abuse of a child, abuse of an elder, abuse of another person, some serious types of abuse can run into something called the Adam-Walsh Act. And the Adam-Walsh Act has to do with those more serious crimes where immigration has an assumption that because the petitioner committed certain crimes, they need to show that they've been rehabilitated and that they're not going to be a danger to that individual. So to kind of answer your question as general as possible, since I don't have the criminal records in front of me and don't have all of the details, first and foremost, it has to be disclosed, and the impact is really going to depend on the specifics of that criminal case, and yeah, the specifics of the criminal case to determine what that impact would be. So hopefully that helps answer your question. That's definitely a really important consideration when you are preparing that fiancé visa application to file. Okay. All right. So you're working on your removal of conditions application, and you're wanting to know about how much evidence. So when you're going through the removal of conditions process, immigration is looking at your relationship again. They're scrutinizing your relationship again to decide whether or not they believe that your union is 100% bona fide. So yes, checking and having financial accounts is something that they're looking for. In terms of how much evidence that you need to include, the standard is that immigration is looking for relationship evidence from marriage to present. So you want to be really thorough in your submission. There's not necessarily a set amount of bank account statements, but you do want to ensure you're covering that entire period of time from marriage to present. And so often what we do with our clients, it really just depends on the types of accounts that they have. But we typically want to include at least statements that go as far back as the marriage as possible to present. So just make sure that all of your evidence is covering that timeline. Okay. Okay, so you're asking on the fiancé visa that you filed in February, how many days after filing will you be notified? So for I assume you when you say you submitted your fiancé visa that you mean you filed the initial petition in February. After you file your application, if you filed, there's a certain form of G1145. If you filed that form for notifications by text and email, you'll typically receive that within a few weeks of filing. And then there will be a paper receipt notice that comes in the mail about a month later. From there, I know you're asking, how long does the interview? When will the interview come? I did make a video on this recently, and Ria can throw that in the comments for all of you. It does take about 14 months right now from filing the petition to actually receiving an interview. Of course, this is an estimate, and it really varies on the country and also whether or not you're part of that 39 country pause. So some of those considerations and the wait time, but on average about 14-month estimate. All right, we have a lot of questions coming in here today. All right. Let's see who's next. Oh, Maria, it's so great to see you. Good morning to you as well. Yay. Yes, you're trying to stay optimistic. Yes, your fiancé visa is in transit to the consulate. Ah, such good news. You're getting closer and closer. I know you've been so patient in your waiting. So hopefully very, very soon you'll receive that email from the consulate in Montreal. Oh, it's so good to see you. All right. Who is next here? Monique, good morning to you as well. You're in North Carolina, husband's in Nigeria, and you're counting down the days until we see each other next month for our 1-year wedding anniversary. That's right. You had said that on our last live that you'll be going for that visit. Have an amazing, amazing time. And what a lovely celebration that you'll get to have for your 1 year. So, all right. Who is next here? All right. So you're here, Texas and UK again, and that you're wanting to do the weekly check-in to say hello and learn from the experiences of others to see if anything has changed on the processing times for the spouse visa. And best regards to everyone watching. Right now, spouse visa wait times are ranging anywhere. So that's when I say spouse visa, I should clarify. I-130 petition wait times are ranging anywhere from 12 to 17 months. And that's what we are really seeing. We keep a pretty good finger on the pulse with all of our cases. And that's what we're seeing, about a 12 to 18 month wait. I'd love to hear from everyone in the community here as well. If anyone else has wait times that they want to share on the I-130, I'm sure everyone would appreciate that. So, but that's what we are seeing, about the 12 to 17 months. All right. So for fiance visas, as I had said with the wait time, it is about a 14-month wait, give or take, from filing. So you submitted the fiance visa May 9th of 2025, and you still haven't heard anything. Um, we'd love some hope at this point. Called them and they said everything is normal. All right. So Dalton, yeah, I mean, wait times vary, and that's why I always say it's an estimate. It can really vary based on the case. Hopefully you will have a decision a decision soon. We've seen on average that it takes about 18 months for that petition for the fiance visa. It can take a little longer depending on the specifics of your case. So hopefully you'll have a decision soon. All right. So open Maria, I saw. Okay, so you are at the phase of preparing the removal of conditions for your wife and your stepdaughter. Yes, and that makes sense from the question that you asked earlier. All right. So you said your wife was approved for deferred action, medical deferred action, and she does not have a work permit yet or a real ID. Um, Really, you should talk with your hopefully you have an immigration attorney that's helped you with this. In general, when you're traveling, yes, you could use a passport, but there are definitely risks right now to traveling if you don't have proof of any kind of lawful status. And even for someone who has deferred action and a work permit, there can still be risks in domestic travel. So you need to definitely speak with your immigration attorney who helped with the medical deferred action to understand those risks and what travel would look like and how to mitigate those risks. But definitely, though, ideally, yes, you could travel with a passport, but if you don't have proof of your current status, that can be risky to travel even domestically. Uh, CBP has been asking TSA. So TSA is who checks you when you go through the airport to board your flight, and they have been sharing passenger manifests with CBP, and that has been happening for quite a while, right? Quite a while now, for many months. And so that's the risk, is if you are traveling and you don't have proof of current lawful status and you're traveling domestic, even if you have a temporary status like deferred action and a work permit, you need to understand domestic travel carries those risks, that TSA could share the flight manifest, could share your details, and it's just a stone's throw away to the CBP agents office, right? And that they could get involved. So definitely speak with your immigration attorney about those risks so you can understand and make an educated decision before traveling. Just wanted to see. Yay. All right. Lisa, it's so good to see you. Glad you made it. Yeah, and Daniel, I was just reading your question. So, yes, the most risk adverse position for a permanent resident is to not travel outside of the country if you're on in the banned countries list. It does say, though, I want to be very clear, it does say in the proclamation and the policy that lawful permanent residents are exempt. The risk comes from the unknown. And so we've talked about that before on live events in some of my videos, is that you have to decide what is your personal risk tolerance. The policy says you're allowed to travel, you're able to travel. Legally, that's your right as a permanent resident to travel. But if you have concerns about the unknown, then the safest or most risk adverse option is to not travel. So I want to be clear that it's not that the policy says you can't travel. That's just a position that some individuals take because they just don't want to take any risks. In terms of tips and advice, then going from there, if you decide, hey, I want to live my life, I don't want to live in fear. It says that I can travel as a permanent resident. I want to do that. That's my right. Then understanding your rights upon reentry. And so when you're coming back into the country as a permanent resident, understanding that customs, they do not have the authority or discretion to take away an individual's green card. Can they ask you a prolonged set of questions? Could they attempt to detain you? Could they send you to immigration court? Yes, but there would have to be justification for that. You'd have to have some serious issues in your immigration history for that. But if you're in a situation where customs is giving you a very difficult time as a returning resident, it's important that you only answer the questions that you're asked, that you do not sign anything. So there is a form that customs could make you, CBP could make you sign that says that you're relinquishing your permanent resident status. So it's imperative you don't sign anything. And if you get in a situation where they're not wanting to let you enter, asking them to refer you to an immigration judge, asking to speak with your immigration attorney. And I'm giving you a really high level, like 30,000-foot view of what to do. And Ria, would you throw in the comments the video that I made? It was last year sometime, that was very in depth about traveling as a green card holder. And I went through all the steps that you can take in making the decision, and then also in mitigating issues upon entry. If you can't find it, Ria, just ping me and let me know. But it's on one of the long form videos on our channel. So if you throw that in there for Daniel to reference and anyone else who's a green card holder, that video is very thorough and walks you through information that you should understand before traveling. Goodness, excuse me. I've been talking all morning. Yay! Donnie said that. I'm so excited to see you. And yes, so happy that your petition is approved. So great. Such great news. Super, super happy for you. I feel like I need some kind of celebration stick or something like that or some confetti to throw, because we're just thrilled for you. So congratulations. I'm so glad that you were able to join today. All right. And Daniel, do you think an expired green card with an extension letter would warrant the extra scrutiny you mentioned? No, when I'm talking about cases where there's going to be additional scrutiny or more risks, that would be for individuals who have certain criminal history, typically drug and alcohol related criminal charges, things that are on that more serious level like that, or individuals who've had prior immigration court history. So if they've been detained or they had to go to immigration court, those are the kinds of situations where there's going to be much more scrutiny and much more risk. But having a removal of conditions case pending, like you're saying, the expired green card with the extension letter, you're still a permanent resident. That's not going to call for additional scrutiny. There's always this class of, or camp of thought rather, from practitioners that, well, if you have your application pending, there are risks that what if your application, were denied when you were abroad. But typically what would happen with removal of conditions case is if they had questions, they'd schedule you for an interview or a request for evidence. So that's all to say, no, just having that application pending would not be increased scrutiny in that regard. So hopefully that helps. And yep. And Ria threw in the travel tips video for you. So you can check it out there. I walk through what are some of the situations where there would be more scrutiny and more risk. So hopefully that will be helpful for you. Oh, and Maria saying congratulations to you, Doniseta. Okay. Now I lost my place. There were so many questions. I skipped around just a little bit because I had a bunch of questions that came in through Facebook. All right. So good morning to you as well. You're in California with a fiance visa. And you're getting married today. Oh, that's so exciting. And you're here with us today. How lovely that we get to partake in the festivities of your marriage. So that's exciting. And then you're going to move to Texas in a couple of weeks. And we are planning to apply for her social security number in Texas as well. So that's great. Yeah. So getting married in the 90-day window and making sure you file a solid green card application in the 90-day window is my biggest advice. Making sure you get that filed timely in that 90-day window is super important. And making sure you file a solid application that includes updated relationship evidence. And you can't underestimate practicing and being prepared for the interview that's to come in the future after you file your green card application. And we have a bunch of free resources as well on our website. If you want to check those out, we have a chart that kind of walks through the steps in the fiancé visa process and the adjustment of status process, and a relationship evidence guide. So you can check all of that out. Let's see if I understand what you're asking here. So Rocio, does a request to expedite for overstay with strong and solid evidence have any chances of being granted? What is your opinion about these expedite requests? So I'm not sure what you mean for an expedite for an overstay with strong and solid evidence. I'm just not sure what you mean by the overstay piece. Here, I think, okay, that's why I was just scrolling down to see if you had thrown any other, okay, yeah, you did throw another part. So basically you're asking about an expedite request for a 601 waiver. And yeah, basically that's what you're asking about is as expedite requests for 601 waiver. The expedite requests are a great tool, and it's really important to understand that expedite requests are rarely approved. You have to have very, very serious circumstances for an expedite to request to be approved. So for everyone who's like, what is an expedite request? If you have a pending application with immigration, any type of application pending with immigration, and an emergency comes up. So we're talking life and death type emergency, you can ask immigration to expedite your case. So you have to have, like you said, strong, solid evidence of why your case should be expedited. The reason that expedites are rarely approved is because immigration says, and it's true, you're asking to have your application basically taken out of line and reviewed before someone else's application who's been waiting longer than you. So it has to be a very serious, very valid reason for immigration to be willing to do that. The tricky part with 601 waivers, any type of waiver application, is that with the waiver application, you have to show immigration that the US citizen or lawful permanent resident petitioner would suffer extreme hardship. So everybody who's filing a waiver application is in that situation of a more extreme level of hardship. They're in, oftentimes with waiver applications, they could be already in a situation of life or death. So it's much more rare for immigration to approve an expedite for a 601. Is it possible? Have I had them approved? Yes, but you have to not just have solid evidence, but a very well-crafted legal argument to make to immigration for them to even consider it, and still understanding that typically immigration comes back and says, yeah, we understand that you have these extenuating, difficult circumstances, but so does everyone else that's waiting for a waiver. So I'm not saying it's completely hopeless, but to set realistic expectations, that's that just so you kind of understand what that looks like. And yes, so you're saying he's 86 years old and a cancer patient. Yeah, I'm really sorry to hear that. That's so difficult. And so it's not that it's not worth trying, but you get one shot and you want to make sure you do it right. Have that solid evidence, and not just the solid evidence, the process in which it's submitted, having a solid legal brief that helps the adjudicator see why, they should approve the application for an expedite request. So it's worth trying, but I'm also just wanting to set some realistic expectations, which I'm sure you understand. So if you have an immigration attorney that's helping you with that process, great. Make sure that, like I said, you have that one shot that it's done well. And if you're looking for assistance with that expedite process, I'm happy to speak with you in private in a consultation if you're wanting assistance. All right, we have a couple more minutes. I'm going to see how many more questions I can get through here. Patricia, this is not a weird question. It's a great question. A lot of people ask this question. If you can, while the application is pending, can you live together in another country while you wait? And we have a lot of couples ask this question and actually do this. The wait times are long, and you can't control the wait time, but you can control how you structure your life. And for couples who are able to live together, that's fantastic. And it is possible to do that as a US citizen, to live abroad with your spouse during the process. And if you do that, you just have to be aware of the additional considerations when you're living abroad, because part of the immigration process, you have to prove to immigration that you have domicile in the US, which is a legal term of art that says that the US is your home in fact. When you're living abroad, that's going to require you to provide additional proof to show that the US is your domicile, making sure you're filing taxes, maintaining your voter registration, maintaining financial accounts in the US, and the list goes on. So it is possible. You just have to be very intentional and strategic in doing that, so you don't run into issues with the domicile requirement. Rocio, you're very welcome. I'm glad that was helpful. All right, and Monique, you're telling them congratulations on getting married today. Okay. I'm trying to go in order, and I'm trying to get through as many questions as I can. I think we're making pretty good progress here. All right. Yeah, so Ted, Monique was telling you congratulations on the wedding. All right. Or I'm sorry. I think I wasn't Ted. I just have so many questions coming through here, but Ted, you are the next question in the queue. You're from the DR, you're visiting your wife from New York. You filed the I-130 in 2025. You love the show. You think it's very informative. Glad to have you here. Glad to hear it. And then any idea how current administration will affect immigration? So there's a lot of impacts from the current administration. Namely, the biggest policy changes. There were over 400 policy changes last year alone, but some of the biggest ones were in June and December last year with the 39 country travel ban, the reciprocal USCIS pause, and then later the 75 country pause. There's a lot of litigation going on right now, and we're hoping to see some positive changes on that front. But those pauses and travel bans have been some of the biggest changes that we have seen. But immigration attorneys and organizations and clients across the country are fighting against those changes. And like I said, there's litigation pending, and we're hopeful for some positive change. All right, I can do a couple more. Yes, you're very welcome. I'm glad that was helpful, and I'm glad that you're in that category of couples who might be able to live together. That's so good. Not very many couples can do that during the process. Okay. So Nishita, you said that you had an interview in December in 2025 and you still haven't heard anything. It was for an adjustment of status, I-485 and I-130. It is common after an adjustment of status interview for it to take many, many months for the officer to make a decision. It doesn't necessarily mean that there's anything wrong with your case. It's just that particular adjudicator. And we have seen prolonged delays post-interview, not in all cases, but in a lot of cases where after the interview, the officers just have so many interviews to do now because they're interviewing everyone and their caseloads are they just have such a high volume is what I wanted to say of cases that they're interviewing and reviewing. I've had a lot of immigration officers across the country say, it's going to take me months before I can complete my checklist and make a decision. I'll let you know when I'm able, but I'm completely inundated. So it is normal. So, you're asking when you can expect a decision. It could still take many more months, or, it could take a few weeks. It's just really going to depend on that immigration officer, but it's not uncommon for it to take 3, 4, even 6 months after the interview to receive a decision. So, but hopefully soon. I know waiting is the hardest part, right? I know all of you can agree with that. All right. I'm going to see if I can grab one more question here. Okay. I was going to try to grab a question from someone who hadn't been able to ask one yet. I think I have one right here. Miguel, you're in Chicago. And is the partial government shutdown going to have any impact on the operations of USCIS? Your wife is still waiting for her receipt for her I-751. Yeah, the I-751 and really any receipt notices can be delayed in arriving. The shutdown, though, does not have a direct impact on USCIS applications because USCIS is fee funded. So the fees that you pay is what helps immigration USCIS operate. So hopefully you'll get that receipt notice soon because I know that's your extension, right, for your green card. It's really important. All right. It was great to be with all of you. You're very welcome. You're very welcome, everyone. All right. I will be back next week, Tuesday at 11 a.m. Eastern time. I know we weren't able to get to all of the questions, but I will be back next week and I'm happy to answer those next week. If you're watching this on the replay, please do a hashtag replay. Let me know what your questions are. I do go through those. Because if you have that question, likely others do, and it will give me inspiration for the videos that I should make for all of you. All right, everyone, take care of yourselves, take care of each other, hang in there, and I will see you all next week. All right, bye, everyone.